There we are. Well, good noon, everybody, and welcome once again to the Wednesday SCA New South Wales webinar. As always, we are delighted that you decided to join us to develop your skills, further your training, and find out what is going on in the world of Strata. This afternoon, we're going to take a deep dive into the Stage 1 statutory law reviews in New South Wales that are coming up and that were introduced to Parliament back in October this year for both the Strata Schemes Management Act and the Development Act. Now, joining us to introduce us to the Stage 1 reforms, we have Amy Stiles, who is the Managing Lawyer at the Policy and Legislation Office of the Registrar, and I'm reliably informed, no relation to our good friend Karen Stiles at OCN. We also have Lachlan Malloch, who is the Principal Advisor at the Office of Strata and Property Commissioner. And joining us to share their thoughts, insights, and expertise, we have Lisa Pereira, who is the CEO of Strata Plus and SCA New South Wales board member, and a man who, as always, needs no introduction to our Wednesday webinars, Tony Irvine, who is the founder and managing director of Your Local Strata and current SCA New South Wales Senior Vice President. Now, two very, very quick reminders before we get into today's webinar. Don't forget that the SCA New South Wales Christmas party is on Friday, the 24th of November at the Veranda Bar from 6 to 9 p.m. If you haven't registered, please do so because it is always a popular event and generally sells out. And secondly, be sure to follow SCA New South Wales on all the usual social media platforms, including LinkedIn, Instagram, and Facebook. You'll also find recordings of all of our Wednesday webinars on our SCA New South Wales webpage, where you can go and find them. So you can go back and look at everything that we've done over 2022 and 2023. For those of you who are following YouTube, you'll also know that we have a number of videos that we've uploaded there, particularly on the function of the Strata Committee, how owners can pay their Strata levies, and what the function of Strata managers is. So these videos are intended to be a resource for members, so you can use them in your own education programs for your owners and Strata residents. Now, on to today's webinar. As I said, we have two very senior people joining us from the New South Wales Government, if I can say that. Amy Stiles, who is the Managing Lawyer of the Policy and Legislation Office of the Registrar, and a friend of SCA New South Wales, Lachlan Malloch, who's been on to a few of our webinars to walk us through the Stage 1 Strata reforms, which have been long coming, introduced to Parliament, as I said, last month, and they are due to be commenced later this month. Again, very, very important that members understand and know what's going on in this regard. So I'm going to hand over to you now, Lachlan, who has prepared a presentation for us, and you're going to go through what the Stage 1 reforms are for the Management Act, and I believe Amy is going to cover what's in the Development Act.
That's true. A very big thank you, Stephen Brell and SCA, for having us on board. I'll move through fairly quickly so that we can get to some of the more detailed information for you this afternoon, as well as plenty of time for questions and answers, because that's probably even more valuable for you all.
Absolutely. Sorry, mate, I didn't forget. This is our second last webinar for the year. I forgot to mention to all of our members and everyone online, if you do have any questions for our panelists, please do not forget to put them in the Q&A function, which you will find at the bottom of your Zoom screen, and we will get to those as we go through the webinar. Sorry, Lachlan, back to you.
Thank you, Stephen. So we've been introduced. I'll just give you a quick idea of what we're going to run through. I'll give a quick introduction to what this process is and where we are up to, and the approach that the New South Wales Government is taking to this set of reforms. Amy Stiles will take over to talk about some key changes to the Strata Schemes Development Act that are part of this Phase 1 law reform process. Back to me to talk you through quite a few recommendations from the review that have been legislated into the Strata Schemes Management Act. And then we might give you a sneak peek of what's coming in Phase 2, some of the big ticket items next year. So straight into it. Well, in 2020, we kicked off what we call a statutory review of the laws that govern the entire life cycle of strata schemes in New South Wales, the Strata Schemes Development Act 2015 and the Management Act 2015. This is actually required by those 2015 laws that the Minister undertake a review of the entirety of that legislation about how well it's working, is it achieving its intended objectives, and table a report in Parliament on the review. Amy and I worked together on that, and it was a big project to which many of you, and certainly SCA as a whole, contributed very strongly. We made 139 recommendations, many of which were for change to improve the way the strata laws operate, and some were recommending no change and that the status quo should be left in place. That report was tabled in New South Wales Parliament in November 2021. And as Stephen Brell said, there has been some time elapsed since then and a change of government. And so that has also taken up a bit of extra time. We grouped the recommendations and findings of the review into 4 major themes. They were that improved governance was needed, and this would be achieved through accountability and transparency. Building defects needed to be better dealt with, especially the prevention of defects arising at all through the governance and management of a strata scheme. Whereas identification and rectification of defects was already a theme of the 2015 reforms. The report said that the laws could better support competition and address escalating costs for consumers, and that there was room to legislate for more flexible management and administrative arrangements. So where are we at now with all of that? There are going to be 2 phases to the reforms arising from that major review. We are in phase 1 now. As Stephen said, the legislation is in Parliament with changes to the Strata Schemes Management Act, the Strata Development Act, the Community Land Management Act, and the Community Schemes Development Act. So we're keeping those sets of laws aligned across the 2 regimes, community lands and strata. Why are we doing 2 phases rather than one big hit? Well, the 139 recommendations includes over 100 changes across 2 or 4, I should say, acts of Parliament, which is a big project for anyone to undertake. There are also supporting programs of work recommended in those elements of the review. For example, education and training initiatives for the sector, which aren't dependent on legislation. And there are some reforms that were more urgent than others for people in the sector, and we identified those as quick wins that could be legislated relatively early in the term of the new government. And the last reason for the 2-phase approach is that some of the bigger ticket items, the bigger challenges that are coming in 2024 need more policy work done to get the settings right and really get to the nub of the problems we're trying to solve. These phase 1 reforms that we're going to run through today will commence by the end of November this year, the end of this month. We can't say exactly when because it depends on the passage of that bill through the lower house of Parliament and then assent by the Governor of New South Wales. And then phase 2 will take place next year and pretty likely into the following year. So that's the setting of the scene. I'd like to hand over to Amy Stiles now to run through the Strata Schemes Development Act reforms.
Thank you, Lachlan, and thank you for having me here today to speak with you all. We at the Office of the Registrar General are responsible for the Strata Schemes Development Act, and that's something that probably doesn't greatly, come into the thoughts of the audience. But the Development Act is the legislation that sets out requirements for strata plans. It talks about the creation, the variation, and the termination of a strata scheme. So it's sort of at the very beginning and at the very end of the strata life cycle. One area that has garnered a little bit of interest over the last few years under the Development Act is the Strata Renewal regime. And that was introduced in 2015 when the legislation when it was introduced. It commenced in 2016, but it was a new process. And the Strata Renewal provisions in the Development Act are those provisions that allow a strata scheme to terminate where not everyone agrees, but at least 75% of owners are in favour of either a collective sale or a redevelopment of the scheme. So this was a really big reform that was introduced in 2015. It was something that was developed with a lot of protections in place because by allowing not all owners to agree on a renewal, you are, of course, having some in dissent, people who don't want to sell their lots, people who are effectively having their homes sold, even though they don't agree with the process. So there are a lot of safeguards in the regime and a lot of protections. Most of those were aimed at the dissenting owner and those particular vulnerable dissenting owners. So things like requirements for valuations through the process, things like the need for compensation to be determined on just terms. Importantly, the oversight of the Land and Environment Court. So once 75% of owners are in favour of a collective sale or redevelopment, there needs to be an application to the Land and Environment Court. The Land and Environment Court won't approve a strata renewal unless it is just and equitable to do so, unless owners get fair compensation, and unless each of the steps in the process, which is pretty lengthy, have been followed properly. Now, why I'm giving you an overview of what the provisions currently say is because we saw in the statutory review that some of those provisions are not working the way that they were intended. So I mentioned before the steps were included to give protection to people who are generally vulnerable people in dissent, but it transpires that not all dissenting owners are vulnerable, and we've seen instances where other developers are actually acquiring minority interests in schemes and effectively blocking a strata renewal, which has the support of most of the lot owners. And that's what happened in Macquarie Park. I mentioned this one because it has received a bit of media attention, and it is effectively a couple of related schemes in Macquarie Park where more than 75% of owners were in favour of a collective sale. They had gone to tender to find the developer who would be ultimately buying the property, the full 2 blocks. They selected their winning developer, and an underbidder, a competing developer, ultimately bought lots in the scheme and was able to use that minority interest in the scheme as a dissenter to block the progress of the strata renewal. So legal proceedings took several years, costs escalated significantly, and effectively this dissenting developer has really held the scheme to ransom. Owners can't move forward. They had a plan to sell the scheme, to redevelop it. Obviously, costs are increasing, levies are still owing and payable, but they can't move forward. And one of the protections that's in place that was there to obviously ensure a safeguard for dissenting owners is that an objecting or a dissenting owner isn't required under the current legislation to pay any of the legal fees of the owners corporation for a strata renewal proceeding. So ultimately what happened here in Macquarie Park was they were taken to court on several occasions, plenty of interlocutory proceedings, so little procedural discussions in court to try and work out minor areas of difference, but nevertheless, at every opportunity, the dissenting owner, the developer, was able to object and bring the scheme to court and rack up legal fees. In instances where that dissenting developer didn't have to contribute to levies that would pay those fees, and was effectively the scheme itself couldn't recover any of the costs from the dissenting developer. At no point in the process was the dissenting developer required to disclose its conflict of interest. That is, that it had been an underbidder in the tender process. Where that would have been helpful was then it would be in the mind of the Land and Environment Court when it was making its orders in various points in the process. So the statutory review really focused on Macquarie Park because it was a pretty high profile issue. It's ongoing. The problem still exists. And we also saw other types of conflicts of interest crop up, not only this sort of underbidder competing developer situation, but we had reports in the statutory review of instances where developers were buying up lots in schemes to block a renewal, not because they're interested in that property at all, but they had a neighbouring development and views might be impacted should the renewal proceed. So little things like that that ultimately became very, very significant things because the owners corporation couldn't progress with their strata renewal. The whole reason the strata renewal came into place in 2016 when it commenced was to overcome what was a pretty rigid process previously, where all owners had to support a strata termination, or you had to go to the Supreme Court for a pretty expensive and lengthy process. So this was actually brought in to give owners that sort of ability to push forward and make a decision, collective decision about the future of their scheme. And the statutory review highlighted instances where the protections were not being used as intended. So what are we doing about this? Lachlan, can you move over to the next slide when you have a moment? What we're doing about this is bringing in some changes in the first phase of statutory review implementation that will address these issues. Now, these are some of the, rather than quick wins, these are the more urgent, more pressing provisions that need to come in. It's why they're elevated to the first phase. What we are doing in the Strata Legislation Amendment Bill is expanding disclosure requirements. So under current law, only members of what is called the Strata Renewal Committee, so that's a body that's established to develop a renewal plan, only those owners currently have to disclose any conflict of interest. What the bill does, what this new legislation does, is to, just go back, please, Lachlan. What this bill does is to require owners to disclose at various decision points. So each meeting along the way in the process is an opportunity for owners who are in a conflict to disclose that conflict. It's not something which prevents the owners from being involved in discussions. It's purely there so that the conflict is minuted, there is a record of it, and importantly, it's taken into account by the Land and Environment Court when making orders, whether it relates to costs or whether it relates to approving the plan. So the court now has the power under this legislation to have regard to disclosed conflicts. And the legislation also deals with that issue I spoke to you about a moment ago in terms of costs. That is, now the court can actually require dissenting owners who have a conflict of interest or who are acting unreasonably to pay the costs of the owners corporation and their own costs. So it clarifies the application of the law where costs are being awarded against owners who are acting unreasonably. So this is aimed at really progressing those types of strata renewals that are in a bit of limbo because of that blocking position that has been adopted. So there's a requirement for conflicts to be disclosed. There is more transparency. The legislation gives guidance as to what might be such a conflict. It's not exhaustive, but does give some examples, like I mentioned before, owning neighbouring property that might be impacted by a development, having a relationship, business or personal or whatever, previous employee, etc., of a developer who is pushing the renewal. There is a list in the legislation of what might be a conflict, and so that is clear in the legislation, but it's not exhaustive. It does mean that there are other things that could be captured here. So if we can go to the next slide, thank you, Lachlan. The other bit of feedback that came to us in the statutory review is that these safeguards are all necessary. It's really important that the protections are in place for strata owners, particularly dissenting owners, but it's a very complex process. And there is it is the case that it's a pretty low take up of the strata renewal. So since it was introduced, only about 22 schemes have gone along the journey. And in fact, only one of those has had its renewal plan approved by the Land and Environment Court. And the feedback that we received to the review is that this low take up has a lot to do with the fact that people are concerned about all the steps that need to be followed, and that if they don't follow them, their strata renewal plan might lapse. It might not be able to progress. And perhaps you might not find that out until you get to the court process some years after you've commenced the journey. So the review recommended introducing flexibility to the process, which has been done. So where we see some flexibility coming in is that the Strata Renewal Committee that is charged with actually developing a strata renewal plan has had its period of operation extended. The current law says it operates for 12 months, after which it is dissolved. The new law says 2 years, and that reflects the practical time taken to develop a renewal. The owner's corporation can still extend that period of time by passing a resolution, but the problem that was reported to government previously was that schemes were worried that they might forget to hold that meeting, have that resolution passed before the 12 months is up and the renewal committee is dissolved and their strata renewal plan is lapsed. So we've listened to that feedback and taken that on board in the process. Separately, there is now a provision under the new legislation that allows the Land and Environment Court to approve a strata renewal plan, even if some of the steps might not have been followed to the letter. I mentioned at the start that one of the protections is that the court has to be satisfied that all the steps in the process have been followed. And that was a real concern, because if you missed one step, or if you didn't allow the appropriate period of time for notice of meetings or issuing of papers, that was one thing that would invalidate your strata renewal plan, and that's a problem. So now the provisions are clear that the court can still approve a strata renewal plan, even if there's a minor irregularity, procedural irregularity. It might otherwise lapse the plan, but what the legislation says is, provided there's no substantial injustice, the court can still approve the plan, and the scheme can terminate.
Amy, can I just before you go on, can I just jump in for 1 second?
You sure can.
My fellow panelist Tony has a question that he'd like to pose to you. So here he is. He was a bit nervous cutting you off there, so I thought.
No, that's fine.
There you go.
And also, Amy, just to give you a chance to draw some breath as well.
Thank you.
I'm somewhat amazed that there's only 20 odd plans that have gone through this in 7 years since it came into existence.
Yes.
And in fact, only one's got through the whole process.
It is interesting, and I'll just add to that. Only 20 odd plans have gone through the process, but actually, what we have seen, the Registrar General collects records of the number of strata terminations generally, that is with unanimous approval, and the number of terminations through this particular process. So we found that schemes have started the process or started the conversation towards a renewal. And we saw that since this process came in 2016, there was a significant increase in unanimous terminations. So we were talking about, 13 per year prior to 2016. Now we're averaging around 70. So it progressively went up over the previous, the last few years. We had a little dip during the COVID years, but now the terminations are back again. And what we've drawn from that is that this process at least has started the conversation, and many schemes have gone along the journey, and ultimately all owners agree. Remember, this is there to deal with the situations where all owners do not. And this legislation's also been under review for a little while, so these changes have been imminent, and you might draw the conclusion that some are holding back to see how the reform is actually going to impact them.
Yeah, I suppose I've got an observation more than a question, and Lachlan, you can jump in on this one as well. With the current housing crisis in terms of availability of stock, you would think a provision like this, where you can do urban renewal or strata renewal, would be going gangbusters. So there's clearly something in the value chain that is stopping this stuff occurring, and it's probably the planning approval process within the local governments. That's the handbrake to happiness.
That may well be a part of it. One of the aspects of the statutory review that we heard was that the flexibility issue was really a key. Developers were not wanting to embark on this journey with schemes unless everyone agreed, because it was not clear whether 2 years down the line, once they were actually getting to the point of court approval, whether or not they might have, done something ever so slightly out of kilter with the requirements in the Act and had their plan lapsed. And in fact, the one that did go through it was in the city. It was mostly it was a sort of apartment accommodation, but it was mostly owned by overseas investors. And one of the issues that the court had to consider was dispensing with some notice requirements because there was a lot of difficulty with serving notice on owners who were overseas. And so that was one of the points that was taken into account in the statutory review, that there are, circumstances do alter cases, and there are instances where some of the strict aspects of the provisions, whilst they're there for protection of owners, it may be very difficult to meet them in circumstances where it wouldn't cause a substantial injustice. So we're looking at this, Tony, on the basis of putting in some leeway for courts to approve plans that might lack the strict compliance with the legislation. We're also building a bit more confidence in the regime. It has started the conversation for many schemes to actually progress to a termination, but we do hear that some have held back on the basis that the process is long or complex, and it's not clear that the approval would be in place at the end. And there is some more flexibility to come in terms of timeframes in the Part 2 reforms. And in fact, one or several of the recommendations for the statutory review is to watch the process as it unfolds with these changes coming in, because at the time the review was undertaken in 2021, late 2021, this regime hadn't really been enforced for very long because it started in 2016, but schemes had to sort of opt into the legislation at that time. So there wasn't really enough time under the belt to see how it would apply. But we're looking at it on that basis, and it is certainly a process to boost housing supply, and it would free up some of these older properties that could create more units, or in places where people want to live, and that's part of the objective of this particular reform.
Really, there's been a couple of questions that have come in.
Yeah, but I am conscious of time because
shall we push on and I can take them at the end?
Yeah, so yeah. I think that's the best way. Thanks, Amy.
Sorry. That's okay. The other point that I wanted to flag on the next slide is one that's probably less interesting to this audience, but I will mention it because it's one of those sort of corrections of possibly over-regulation in the previous legislation. And it is intended to simplify processes for strata owners. So when the 2015 laws commenced, one of the key changes was that for strata plans and various types of strata plans, like strata plans of subdivision or consolidation, being splitting a unit into more than one or consolidating two into one, in all of those instances, unit entitlements had to be certified by a qualified valuer on a market value basis. And this was a new provision that came in 2015 to make a fairer basis for the determination of unit entitlements, which of course are the things that dictate levy contributions and voting rights. Historically, these were based on developer estimates. Historically, these may not have been accurate estimates, and we had the situation where many units had the same unit entitlement, even though they were vastly different in their value. So this change came in to kind of, just really provide a fairer basis for assessment. But a problem arose where we have changes to a strata scheme that are relatively minor, but costs of valuation are going to be quite significant. So the bill deals with a couple of situations where this happens. It's in a particular type of strata plan, so a strata plan of subdivision. That is the type of plan where if you're wanting to, if you've got one unit and you want to subdivide it, you're wanting to split the penthouse into several units, you're doing it through another plan, and it's called a strata plan of subdivision. That generally impacts common property, and usually under the current law, a valuer would have to value all of the lots in the strata scheme to certify as to the schedule of unit entitlement. That's not so bad if you've got a small scheme, but if you've got 100 plus lots, that's hugely expensive because in fact the valuer would have to go in and inspect all of them to make that certification. So the legislation recognises that they can be pretty minor changes in these subdivisions. It might not affect the proportionate unit entitlement for other owners that aren't impacted by this subdivision. And so now valuers have a discretion to not value all of the lots in the scheme. And this is really really addressing a problem that was highlighted in the statutory review, where it became very costly for some sort of minor processes, even to the extent of swapping car spaces, things that would be of no significance to others in the strata scheme but the affected units. But we end up having really costly valuations. So we've removed that requirement under the bill. And there's a few other provisions in the bill that also just remove some of the more complex or administratively burdensome processes under the Development Act. But I will just hand back to Lachlan now to talk a bit about the Management Act. I'm very happy to take questions at the end once we've had a chance to get through the content.
No worries. Thank you so much for that, Amy. Very, very insightful with some of the changes coming to the Development Act. And as you say, I'll hand back over to Lachlan, who will go on with the changes. And this is one really for our audience, which I think is going to be most pertinent, the changes to the Management Act. Thanks, Lachlan.
Okay, thanks very much, Amy and Stephen. So I've tried to group the changes in the bill because there's quite a few. The bill that's before Parliament now implements 31 of the recommendations from the statutory review report. And I thought I'd start with something that's already been referenced in a discussion we had today. Annual general meetings, operation of committees and records of strata schemes, something that's dear to all of your hearts, I'm sure. Couple of extensions of notice periods. An important one that we're going to be looking at more in the next phase as well is the process of developer handover to the lot owners of the strata scheme at the end of the initial period. The documents and records are set out under Section 16 of the Management Act. And at the moment, they're 48 hours before the first AGM. And we received substantial feedback about this and the next item in the statutory review that a lot of lot owners felt quite disempowered by that, and everything was an enormous rush. So we've extended that out to 14 days that the first AGM documents must be available. And the notice of an AGM, not just the first AGM, but any annual general meeting, is to be given 14 days before the meeting, not 7.
Lachlan, can I just ask, with
plus mile delay?
Yeah, with the Section 16 documents, do they need to be loaded onto the planning portal by the developer, or is this just handed to the owners corporation 14?
At the moment, that's handed to the owners corporation, and that will remain in this bill. But one of the things that's coming in the next phase is that developers will be required to upload the documents to a central repository so that lot owners and strata managers can access them, and then there'll also be a permanent digital secure record of those foundational documents of every strata scheme. So that's a next year project.
Lachlan, can I just clarify, just because there's a lot of strata managers that are really listening to this. Your notice of AGM is 14 days. That's 14 clear calendar days. So not business days, calendar days. And you don't count the day of issue or the day of receipt.
Like the rules about counting haven't changed.
Yep. Okay. And then you've got to add your mail delay, which is 7 business days to this. If you're mailing it out, it's plus 7 business days.
Have you got a lot of strata schemes and under management that have got electronic service of notices?
We do,
but that's an opt-in, not an opt-out basis.
Yeah, and for most owners corporation, it'll be a bit of a hybrid situation where there'll be some owners getting notices via or electronically, and then others getting it via post. So again, I think what Tony is trying to highlight here is that the service provision is going to blow out, probably somewhere around 21 plus days for some owners corporations to make sure that their AGM notice period is correct.
Yeah, you're in the mid-20s, I would have thought on this. And then if you're running across Easter, that really hurts you because you've got so many public holidays. So
good argument for digital adoption, then I'd say.
Yeah, I know, but you can't mandate that. If the owner wants to get it by paper, then your notice period is 7 business plus 14 calendar. If they all agree to get it by email, then it's 14 calendar days notice.
Sure.
Geez, I sounded like Benneman's there, didn't I?
So then we've got a few things around conflicts of interest, and there may be more in phase 2, but we'll see about that. The stuff we've got on the table right now is that committee members at the moment under the current laws are only required to disclose conflicts of interest when matters affecting them or that are influenced by a conflict of interest are under discussion. But the reforms actually take that a step further and say that the committee member with a conflict of interest will recuse themselves from the decision-making process in those cases. And committee members can now, or at the end of November, will be able to be removed from the committee more easily by an ordinary resolution of the owner's corporation rather than a special resolution, and that prohibits them from serving again for 12 months. And another one is that the size or the maximum size of committees in community lands, association committees, has been extended to 15 members. Further on the same themes, there's a requirement for schemes to keep their records electronically. It doesn't affect historical records, and it doesn't mean you can't still have paper copies of things, but there is a move to ensuring that strata schemes hold their records in an electronic form. Tenancy notice for the strata roll is a pretty well-known problem that many strata rolls are inaccurate because tenant notifications don't happen. So leasing agents under the Property and Stock Agents Act will now also be liable if their tenants are not notified to the owner's corporation, and tenants will have a process to provide their own notice that they are the tenant of a particular lot so that they can get on the strata roll, and emergencies and all sorts of other things can be better handled. The limits on proxy votes that were introduced in the 2015 reforms have now been extended to people acting as company nominees and under powers of attorney. And there's also another one that's been bothering some people, is the question of whether bylaws made under previous strata law regimes remain valid because the laws have changed and moved on many times since then, over several decades in some cases. So we've clarified that bylaws made a long time ago are still generally valid. They don't need to be remade, but they must actually, or they can be challenged under current laws. For example, the new restrictions that have come in recent times on the sorts of things that bylaws can and can't do. One that's dear to all of your hearts, the way managing agents and finances are governed. Well, renewal of the Strata Managing Agents Agreement, as you know, must be notified to the owner's corporation if the managing agent would like to continue. At the moment, a minimum of 3 months before expiry. But there's actually no maximum period. And so we found out in the statutory review that some agents were being a little cute and providing their notice of renewal at the same time as they signed up an owner's corporation. So 3 years notice rather than 3 months. We're saying it must be provided between 3 and 6 months before expiry. Fair trading will have standing in the tribunal to apply for the appointment of a compulsory managing agent, which the regulator does not have at the moment. And this is a bit of a theme of more proactive involvement in strata scheme governance that is emerging over the next little while. Clarifying the rules on transfer of funds between administrative and capital works funds. That has been a source of some debate amongst people who like to debate legal points over the years. And the grace period for the payment of special levies has been reduced from 30 days down to 14 days in cases where those levies are being struck to carry out urgent repairs for safety reasons. $30,000 expenditure and more. At the moment, it's only large schemes have to obtain more than one quote, with some ways around that, of course. That particular rule is being extended to all strata schemes. Going through this quite quickly because of the time factor, folks. I want to leave time for questions and answers.
Yeah, and Lachlan, the way you're going, our Q&A board has just exploded.
Okay. How do you want to play it, Stephen?
No, keep going, and we'll
keep
push
plugging away.
Through
Yeah. I'm getting close, I tell you. Now we've got the cutest slide of the day, which is all about pets and assistance animals. So the Strata reforms that took place in 2021 around the keeping of pets are being extended to community lands. And that's one that will commence later because it depends on regulations being made to support the operation of that law. And, it won't commence right on assent at the end of November. And this is a new one as well. The requiring fees, bonds, or mandatory insurance as a condition of applying for approval or keeping a companion animal will be prohibited. There's a new restriction on bylaws that prohibit an assistance animal from performing their duty. You can impose all sorts of rules on how people move their companion animals through common property and so on, but if it's an assistance animal, then they have further rights. And also a question that's come up a lot is what are acceptable forms of evidence to prove that an animal that a Strata resident is keeping is in fact an assistance animal. Those forms of evidence will be prescribed in regulations that are coming later. So we'll leave our pineapple cats and move over to this is a little bit of a sneak peek of part 2, which is that the legal statutory duty of owners corporations to maintain and repair has got varying levels of compliance and is the source of many disputes and complaints to fair trading and so on. So there are new powers coming in the building law reforms that are going to go to Parliament next year, which will extend fair trading's power to issue orders to an owners corporation of a strata scheme at any stage of its life and not just in the building and development phase, which we're seeing now. Of course, we want to help owners corporations comply with their obligations, but ultimately there must be consequences for regulatory consequences for neglect and willful neglect. I won't go too much more into what's in phase 2, but it is about some of the bigger challenges that we've got on the road ahead. We expect to have draft phase 2 legislation for public comment at some point in 2024, first half, and we're consulting with SCA leadership on the contents of that now in a couple of stages. We've got some big challenges that I must say and thank SCA for partnering with the Office of the Property Services and Strata Commissioner with roundtables and expert working groups that have surfaced a lot more diagnosis of why there are some certain problems happening in the governance of strata schemes. So we'll be looking at developer compliance more closely, including the types of representations they make in their off-the-plan sales, of course, improved capital works fund planning, closing loopholes and ensuring better deals on embedded networks. Like I said before, first are AGM records and documents to be uploaded to a central platform, prohibition on unfair contract terms in standard form contracts made with owners corporations, and some initiatives for committee education and empowerment. That was a record time.
Well done, Lachlan.
Over to you, Stephen.
Yeah, no, mate, thank you so much for that. As I said, and I do thank profusely Tony and Lisa, who, once Lachlan started with these reviews, our Q&A board exploded, and they've done a very good job of answering a lot of the questions and comments that came online. Lisa, I might turn to you first up, if you don't mind, because I know that you've flagged a couple of questions here that you'd like to pose to Lachlan and Amy, if you don't mind.
Yeah, some of these are curly ones, so hence why it's I was saving them for you guys. So one of the questions that have come through, the company nominee restrictions seem heavy. If I own 3 units in a 10-lot scheme under my super fund as a PTY limited, I'll only have 1 vote, assuming it is going to be 5% rule like proxies.
I think what the comment there might be, Lachlan and Amy, is that the proxy for provisions seem to be like a one size fits all. So, and another comment which I saw come through is, shouldn't the proxy on company restrictions be only limited to the developer of a scheme, not so much anyone who owns under the name of a company? Now, I know that these have gone through, and I know that they've already been out for public comment. However, these are just some of the things which our members have come up with during your presentation.
Yeah, well, operation of them in practice is always the most important thing. So if is it the same? Is it the same company that owns 3 lots? Because
Often
if
what
they were
happens
3
is-
different companies.
No. Often what occurs is, and I think what the question poses is, where a person has, and they're not the developer, they might have bought 3 or 4 lots under a superannuation fund, as an example, in a strata scheme. And might be a smaller strata scheme, say a 10-lot scheme, and all of a sudden they're going to find their voting right reduced to 5%. Rather than what they would have thought, perhaps 30 or 40% of the owner's corporation. So there might be an unintended consequence there.
Not if it's the same company that owns those 3 different lots. I'm saying it's a person who takes a company nominee vote like a proxy on behalf of many different owners.
Right.
So it is very similar to this proxy idea. Yeah.
Okay. Fair enough.
So if they are the same company, they can have different company nominees for that lot.
Or if the same company, they can have the same company nominee for all lots.
And they still get 3
owner.
votes. They still get 3 votes. It's
so we're not against people owning more than one lot, or entities owning one lot and exercising their rights accordingly. It's where they're basically hoovering them up on behalf of many different parties is the problem that we were trying to solve in 2016 and sort of further closing loopholes now.
Yeah. Okay. As you said, I think further clarity will come once the provisions come into law. Lisa, have you got another one for us that you want to pose for Lachlan or Amy?
Yeah, this was with regards to pet bylaws. What do the buildings who already have the bonds in effect? What happens then?
No, those bylaws will become invalid. So
and practices will change.
Do they give the money back then? The bond?
That is a matter for the individual owners corporation with the professional help of their SCA PSS strata manager to work through. The law doesn't make the law won't make a direction one way or the other.
Yeah.
But no, there's no requirement in the law for refunds of actions done in the past.
Very nice flick past there, Lachlan. Speaking of flick, Tony, I'm going to go to you for the next question, please.
Cool. Look, there's a heap in there. I think these reforms are good. I think we needed to clean up some stuff on 2016, which is great. There's a question that's come from Anthony Coates. What about proxy farming by someone who has a conflict of interest? So is the conflict of interest declaration a declaration by the owner or someone, be it a company nominee or a proxy holder, declaring that conflict of interest? Sounds like it's a good question.
Yeah, I might need a bit more clarity on that one, and
maybe we'll circle back.
Taken on notice, perhaps. Yeah.
Because there will be situations where the proxy holder will have a conflict, not only the owner and that sort of stuff. So, Auntie, that's a really excellent question. Luke Derwent raised a point which I'm not sure I super agree with, that the current market prices is sort of makes it hard for developers to get a return if they're going to do an urban renewal. I actually disagree with that, because basically the developer's return is based on how many lots they can put on top of something. So if your floor space ratio changes, that's where the numbers come up for the developers. So that height is the key determinant on that. And this comes back to Amy and Lachlan, to a point I made, that the reason you're not seeing a lot of strata renewal is because of the planning process is not allowing the density, even though there's a pent-up demand for new apartments.
Yeah, I think that's right, Tony, to an extent. In terms of the comment, though, the return on the investment, I would agree with you that what we're looking at is not developers putting exactly what's there again back on a block. I mean, we're talking a lot about the old red brick unit blocks that have 4 units or maybe 6 units in them or something of the kind, and the potential is much greater to deliver something else. So obviously it's going to be up to the developers to work out whether it's worth their while, but market value is the compensation at least that an owner is getting if they are being effectively forced to sell through this.
Well, that's regime. Right. If you don't mind me jumping in, there's no guarantee that a developer will, if the market conditions are right, will actually provide more housing on a site. they might take a relatively rundown 6-unit block or 12, say, and have fewer lots, but a more luxurious setting that can actually score them a return. So, you know, there's different ways of slicing and dicing it.
Yeah.
One of the questions that came from Renee was about your point in the grace period from 30 days to 14 for special levies. So just to clarify my understanding of that, currently there's a grace period of 30 days before interest can accrue. It looks like the proposal, or what the new law will say, is that on special levies, their grace period is only 14 days. So if they're more than 14 days late, interest starts accruing back to the original due date.
Yeah, if the levy is being struck for, which, you know, special levies typically are, you know, a safety, urgent repairs that affect the safety of the building.
Not really. They're often just for painting or for, you know, repairs and capital improvements and that sort of stuff.
Yeah.
I'm not sure our computer
in that case,
systems. Yeah, I'm not sure our computer systems are smart enough to recognise a grace period that's different. Brelly, you've got a pretty smart system. Do you reckon yours could do 14 days?
Yeah, we can, because we delineate between levies for BMCs and so forth. But it's a very good point that you raised there, Tony, and something that we'll need to let the software providers aware of. It is a common misapprehension that special levies are only raised for emergency works, because often they are for planned or staged works, as you rightly say, for remedial type works and so forth. So it's something, that we need to be mindful of for sure. Lachlan, I got a really interesting one here from Michelle, and it's in relation to the removal of a committee member for 12 months. She says here, will this be past the next AGM, or will the 12 months be for a literal 365 days? So this is where if someone's expelled partway through the year, as an example, can they nominate at the next AGM?
No, they can't, because it's a 12-month exclusion.
So it is for a literal 365 days. So very, very good question from Michelle. Lisa, I know that you're busy in the background typing away, answering other questions. Anything that you can see here that you want to pose to Amy or Lachlan while we're here?
I think this was more so for Amy. In the process of a renewal, what is the need for legal advice representation?
Yeah, that's a good question. So the Strata Renewal Committee, which is investigating whether a plan's worth pursuing or developing a Strata renewal plan, is able to engage professionals, whether they're lawyers or otherwise. So the legislation doesn't require it, but the scheme may choose to do so, particularly once you've had a look at the steps to follow. The Office of the Registrar General has a guide on its website. It's a guide to preparing a Strata renewal plan, which talks about the steps that need to be completed and highlights the need for potentially for schemes to get legal advice. As for owners who are then presented with a plan, the legislation provides them with at least 60 days to consider a Strata renewal plan. And this is what they're given to work out whether or not they want to be part of that 75% approving it. That 60 days is a long period. It's intended to allow them time to digest it, get their own legal advice. And in fact, the Department of Fair Trading has established a legal advisory arrangement with Marrickville Legal Centre to assist owners in that regard as well. So the legislation isn't requiring the advice, it's empowering those to get it, but it's certainly something that both the scheme itself and owners who are being asked to look at a renewal plan would consider pursuing.
Fantastic. Lachlan, I've actually got a question regarding Fair Trading's ability to make an NCAT application for a compulsory appointment. Have you got any examples of the circumstances where this might arise? Like, is it purely going to be driven by what the regulator might be seeing, say via the Strata Hub, or would an individual owner be able to approach Fair Trading and to act on their behalf?
Yeah, the types of scenarios we're seeing typically involve very concerning failures to maintain and repair common property. There may be some lot owners who have been attempting to take action and finding themselves stymied by either apathetic or hostile other lot owners. So these are particular case studies that we've come across and have always involved a complaint to fair trading and sometimes an investigation to have a look at what's going on. I wouldn't expect it's something that the regulator would use frequently. It would be used sparingly. It would, however, empower some lot owners and so on who, I mean, they may be an unmanaged scheme and they need a managing agent to get them back on track. Or there's a managing agent who isn't performing their duties sufficiently, you know, and all those kinds of problems can be overridden. It is intended to help rather than penalise. There are just some blockages where, you know, we really felt that at least standing in the tribunal, this doesn't allow the regulator to directly appoint a manager.
No.
This is standing to make an application. So that may be on behalf of, you know, financially stressed lot owners or otherwise disempowered lot owners. I should also say that this is one of the few reforms here that's going to commence a bit later. It won't be coming into force right at the end of November, because we're negotiating with NCAT about exactly how that's going to work.
No, absolutely. Look,
it would only come after a relatively lengthy process as well, I would assume.
Yeah. No, for sure. Again, I certainly take on board that it would be used sparingly. Just interesting how it will be applied by fair trading in that particular circumstance. I'm very aware of time. We've got 3 minutes before we wrap up, and there are a couple of questions here which I'll try and knock over very quickly. Michael asks about the PET applications, and some schemes actually are charging for PET bonds and so forth. Michael, I think the way that this is applied, it purely relates to PET applications. So if owners corporations have other types of application bylaws in place for renovations and so forth, they are currently still in. However, the government is very much on a pet-friendly, I won't say rampage, it's not quite right, but they're in a pet-friendly mode at the moment, trying to get promote pets in strata schemes. So that particularly item only applies to pets. Henry asked, this might be something for stage 2, Henry. He asked, are there any provisions or discussions for vehicles to be towed or penalised quicker than through NCAT? I haven't seen anything like that in the reforms, and Lachlan shaking his head. So I think that's a fair one to say that no, there is nothing in there about that in either stage 1 or stage 2. Maybe something, Henry, that you want to bring up for stage 3. My goodness, just in the time I'm talking here, there's a whole bunch of other questions come in. Tony and Lisa, are you scanning these for me?
I am, but I just wanted to clarify something, because I think I might have misread this 14 versus 30 days for special levies. And thanks, Sean Birmingham. It's the 14 days is the notice of the due date of the levy, not when it's got to be paid by to reduce to get an interest-free period. I'm pretty sure that's the case, Lachlan, that it's like at the moment we've got to give 30 days notice of the levy.
Yeah.
It's actually a lot more than 30 days because you've got to give the notice period and everything else like that. But it's been reduced for special levies because there will be some urgency around collecting that money. That's what's been reduced to 14 from 30.
Yeah.
Is that your understanding? Yeah. Thanks, Sean, for pointing that out.
Yeah, you're 100% right. It's not the notice of interest, it's the notice of issuance of the levy. Couple of ones here, and again, we've got 1 minute before we... Oh, sorry, go for it, Lisa.
Oh, no, it's just, is the government planning on further regulations for short-term letting?
The planning department is undertaking a review of the planning framework, but bylaws in strata schemes and, you know, the register, sorry, the exclusion register and the sort of complaint handling. What's that code of conduct that I'm trying to think of, that fair trading administers is not being reviewed, and that's remaining in place. So we're expecting something coming from the planning department about a review of the framework that's been in place for a few years now.
And absolutely fantastic. Well, ladies and gents, I've noticed that it's just ticked over to 5 p.m. Please join me in thanking our very learned panelists, Amy Stiles and Lachlan Malloch from New South Wales Fair Trading, and also Lisa Pereira and Tony Ovine for their thoughts and insights today. Again, strata changes, the strata laws are coming. As Lachlan mentioned, we're thinking that they are due to be assented to this month, and as soon as they are, we will certainly be going out and letting all of our membership know when they come into force. Again, this is our second last webinar for the year. Our next webinar, I'm just looking up here, which will be on the 22nd of November. Our final webinar for the year will likely be a little bit of a year in review, and hopefully by then we might even have some new strata laws in place, which we can go over again. But please thank me in joining everyone online and all of our panelists for their thoughts and insights this afternoon, and we hope to see you next time. Thank you all.
Good on you. Bye now.
Thanks, Lachlan.